Mr. Corbett, I think you have 10 minutes.
Yes, Your Honor. Thank you, Madam Chief Justice, and may it please the Court. Hopefully I'll use a fraction of that 10 minutes. The issue that's before the courts with respect to the Nystedt case is very narrow. It focuses only on that interrelation between the Appeals Court Rule 2.201 and this Court's Rule 221 that I argued briefly in the McMenamin argument. Substantively, these cases could not be more different, but the fact that this procedural issue has arisen really indicates why that particular issue is susceptible of repetition, yet escapes determination, because unless this Court reaches out, as it did in the Cordes case, and tells the Appeals Court to interpret it, its rule as written.
Cordes did not involve an appeal from the denial of a petition under 231 Section 118, correct?
No, it involved a motion that was denied by a single justice.
I understand, but we've got a whole raft of cases that deal with petitions under 231 Section 118, and which say that you can't appeal it. And then we've got some other cases, Cordes, which don't deal with 231 Section 118.
Let me deal with these in separate ways. Many of those cases, and the Appeals Court cited to them, predate this Court's 1995 amendment of its Rule 221.
Yeah, but 221 was not intended to change that precedent or create a new right of appeal.
Except the Appeals Court rule says that appeals from decisions of a single justice shall proceed as they do in the Supreme Judicial Court, not as they do in the Supreme Judicial Court as of X date. It was intended, and I think the Court said this in a dictum in Cordes, it was intended to have the procedures be comparable so that you'd have the same rights in that court as you do in this court. And we didn't have that. In fact, this case and McMenamin got to this full court pursuant to Rule 221. That didn't happen in the Appeals Court because instead of allowing that appeal pursuant to 221 and 201 to proceed, the notice of appeal was stricken. And that's the problem here. It's of particular concern with respect to this case. It does arise from a denial of summary judgment in the probate court, and it's axiomatic that in the ordinary course, a denial of summary judgment isn't appealable. But in this case, we're coming from the probate court, which has a different appeal statute. The Superior Court, the Housing Court, the Land Court, they're all subject to Chapter 231, Section 113, which only allows for appeals from final judgments. This decision, which comes from the probate court, is subject to Chapter 215, Section 9, which says that all decisions and decrees and orders of the probate court, regardless of whether they're final judgments or not, are appealable. And when you combine and overlay this court's jurisprudence with respect to the non-appealability of summary judgments, and then you take its treatment historically of the probate court statute, which holds...
But if we buy your argument, then does that mean that every time there's some decree or order in the probate court, some type of custody or visitation, it's appealable?
No, Your Honor. Under the Borman line of cases, it says that these appeals are generally held in abeyance until after the case is finally resolved in the probate court. But that's where we have the problem with the deerskin line of cases from this court, which say that summary judgment's not appealable.
Well, why don't we just apply that also?
Because the legislature said that everything coming from the probate court's appealable at some point in time.
It is eventually appealable.
But didn't you, I mean, before you get to the merits of that, don't you have to deal first with the sort of threshold issue of whether 201 incorporates 221? Because otherwise, I mean, in the appeals court, if the single justice says you can't appeal, that's the end of it, right?
I've seen no authority to the contrary. The closest decision that comes to it is Cordes from the perspective of a litigant in my client's position. But you also have cases like Kratesburg and Janes and Hunt, where in the 211.3 context, petitioners were denied relief because they failed to avail themselves of that mode of redress at the appeals court
Are
level.
you asking us just to tell the appeals court to let you appeal it to the, within the appeals court?
At this point, Your Honor, with respect to Nystedt, it's essentially an academic argument because this summary judgment motion was filed in late '04 because
You've
everything...
got the will gone, I mean, you've got the relief you wanted, right?
We got, it's still subject to appeal, under appeal at the appeals court. There's an active appeal. So this court may get the substantive issues that were addressed, I think, from page 32 on in my brief. I did move for direct review sometime last year. That was denied.
But I take it the answer to the Chief Justice's question is yes, that if somebody seeks relief from a single justice of the appeals court under Chapter 231, Section 118, the decision of the single justice of the appeals court is appealable to the full appeals court.
As the rule is written, yes.
And you were denied that.
I was denied that. And as this
And
court...
that's why I'm saying, up here, what are you asking for? That we tell them that they've got to, that the single justice who struck your appeal within the appeals court from the denial of your 231 Section 118 should go back and have allowed it?
Essentially so, and that's why arguing this as a companion to the McMenamin case is helpful, because that issue also appeared there. I know that with respect to Nystedt, the issue is moot with respect to my client, but it also falls into that line of cases where the court will give instructions to lower courts under the general superintendent's statute when there's a problem like this that's susceptible of repetition without being cured at the appellate level.
But it seems to me at bottom, you're suggesting that we tell the appeals court, you are misreading your own rule, right?
Essentially, yes, Your Honor. And the court did so somewhat gently in Cordis. It was a different procedural route as opposed to the 231-118 route that this case followed. It came up through, I think it was Rule 15 of the Rules of Appellate Procedure, but it was still a decision by the appeals court, and this court said that the appeals court had erred when the notice of appeal had been stricken.
Yeah, but that wasn't interpreting the appeals court's own rule.
This court did say in Cordis that it was necessary for the decisions of single justices to have some measure of review. And as this court knows with respect to Rule 221, it's an abbreviated form of review. I'm not saying that you should be able to get a full plenary appeal of every decision of a single justice.
Well, but let me just see if I have this right. We have a whole line of cases, but put aside Rule 201 for a minute, but there's a line of cases that says a single justice in the appeals court who denies relief under 231-118 first paragraph and denies a request to report it to a panel, that is the end of that particular story, correct? You don't get an appeal from that. That's an unappealable decision.
I don't believe that's correct because those cases, the ones that I'm familiar with, predate this court's 1995 amendment to its Rule 221.
Okay, no, I'm just saying apart from the...
Those precedents say that, Your Honor.
Okay. So your argument depends on reading 201 to incorporate 221, correct?
Yes, Your Honor.
And if the appeals court says we didn't mean 201 to incorporate 221, but you're saying we should say, well, we think you did. Is that right?
As the appeals court wrote the rule, as the rule was written, that's what it says. If the appeals court doesn't want to apply it that way, it can change the rule. And that's certainly its prerogative, subject to the appropriate procedures.
Thank you, Mr. Corbett.
Thank you, Your Honor.
All right.